Welcome to this in-depth explainer on how past immigration history, like a visa overstay and even a prior green card abandonment, can affect your future attempts to become a U.S. lawful permanent resident. First, we will frame the key legal concepts. Next, we will discuss how overstays and bans operate, how a prior grant of LPR can forgive certain past violations, and what it truly means to file Form I-407 to abandon residency. Then, we will shift to the decisive factor, officer discretion, and how your intent and evidence can make or break the case. Finally, we will provide practical preparation tips, comparisons, and a quick quiz to test your understanding. Here is our agenda. First, we will cover the legal framework behind overstays and bans. Second, we will explain the mechanism by which a prior grant of LPR can forgive certain past inadmissibility grounds. Third, we will define what formally abandoning LPR status using Form I-407 means. Fourth, we will highlight the practical reality of officer discretion and intent. Fifth, we will share concrete evidence strategies and interview preparation tips. Sixth, we will use diagrams to visualize decision flows and timelines. Finally, we will test your knowledge with short quizzes. Important disclaimer: this presentation is educational and does not constitute legal advice. Immigration outcomes are fact-specific, and rules, policies, and discretion can vary by jurisdiction and by officer. Before you act, please consult a licensed immigration attorney who can review your personal history and documents. With that in mind, let's proceed carefully and clearly. Let's define the core ideas. A past overstay can trigger time-based inadmissibility bars, such as a 3-year or 10-year bar, depending on the length of unlawful presence and other circumstances. If a person later obtained LPR status, that means the government reviewed and forgave the overstay grounds for that specific adjudication. When that same individual applies for LPR again years later, the decades-old overstay, assuming the ban was served and LPR granted, typically does not reappear as a new legal bar to LPR. However, the same overstay remains a red flag for non-immigrant visas, such as B1 or B2, because they require proof of temporary intent. Next, regarding Form I-407, formally abandoning LPR status generally does not create a new ground of inadmissibility. It is a confirmation that the person did not intend to permanently reside in the United States at that time. Nevertheless, the most consequential factor moving forward is officer discretion. Adjudicators will examine the full timeline and evaluate whether the applicant credibly intends to permanently reside in the United States now. This is why evidence preparation is crucial. This timeline will illustrate a common sequence. First, a period of overstay that triggers a bar. Next, after the bar period runs or is waived, the applicant secures LPR status, which effectively forgives that overstay-related inadmissibility for that adjudication. Then, after a short period, the person files Form I-407 to abandon LPR status, signaling a lack of permanent intent at that time. Years later, a new family petition is filed. Ultimately, at the interview, the officer reviews the entire timeline and assesses current intent, stability, and credibility. Now, let's break down overstay-related bars. Accruing unlawful presence between 180 and 365 days can trigger a 3-year bar upon departure and attempted reentry. More than a year of unlawful presence typically triggers a 10-year bar. Expedited removal often triggers a 5-year bar, and repeat violations can extend consequences. If the person later successfully obtained LPR status, the government would have addressed and forgiven the overstay-related inadmissibility for that adjudication. However, that same overstay history can still damage chances for a B1 or B2 visa, because these require compelling evidence of temporary intent, and a prior overstay directly contradicts that temporary intent. With that foundation, we can turn to what it means to abandon LPR status. Here is a quick reference table. Unlawful presence of 180 to 365 days typically results in a 3-year bar, while more than 1 year of unlawful presence usually leads to a 10-year bar. An expedited removal often creates a 5-year bar, potentially longer with repeat incidents. Fraud or misrepresentation can trigger a permanent inadmissibility that requires specific waivers. This video focuses primarily on overstay-related issues. If an applicant later obtained LPR status, The overstay ground was effectively forgiven for that adjudication. This table should help anchor the key consequences before we consider green card abandonment. Let's clarify I-407. Filing Form I-407 is a formal statement that the person is voluntarily giving up LPR status. Legally, it signals that they lack the intent to permanently reside in the United States at that time or could not meet the residence requirements. Importantly, 407 does not itself create a new ground of inadmissibility. Therefore, if a new qualifying relative petition is filed later and the applicant meets eligibility criteria, the previous abandonment should not block the new application. However, as we will see next, officer discretion and perceived intent now become decisive. On the left, we have the legal framework. Overstay bars are typically time-limited or can be waived in certain contexts. The prior successful grant of LPR generally means that overstay-related inadmissibility was forgiven for that adjudication, and formally abandoning LPR via I-407 does not create a new ground of inadmissibility. On the right, we have discretionary concerns. Officers review the entire history, including the timing of abandonment relative to the initial LPR approval. Abandoning LPR shortly after obtaining it can raise questions about the applicant's commitment to residence. Therefore, the quality of today's evidence demonstrating stability and genuine permanent intent becomes central to the outcome. This decision flow will depict the steps an applicant with a complex history should expect, confirming that prior overstay issues were already addressed during the earlier LPR grant, recognizing that I-407 did not create a new inadmissibility, collecting robust evidence of present permanent intent, and facing an officer discretion node that can result in approval or a refusal or request for more evidence. The flow will also include a feedback loop to strengthen evidence if the case lacks clarity. Next, let's talk evidence. Begin with a clear U.S. residence plan, such as a signed lease or home purchase intent. Provide employment proof like job offers, transfers, or professional licensing where applicable. Establish family ties through documentation of spouse or children's status, school enrollments, or caregiving responsibilities. Show a financial footprint through bank accounts, tax filings, insurance, and credit history. Demonstrate community involvement with memberships or volunteer commitments. Include a concise personal statement explaining why you are permanently relocating now and how your circumstances have stabilized. Add affidavits from reliable third parties such as employers or community leaders. Show consistent travel patterns that align with permanent relocation, avoiding extended absences. Finally, assemble everything into a clean, organized packet with a cover letter, index, and labeled exhibits to help the officer navigate your case. As we move into interview guidance, be candid about your prior overstay and explain how your circumstances have changed. Describe why you filed I-407 in practical terms, such as employment or family obligations abroad, and show why those conditions no longer apply. Focus on present-day stability, including employment, housing, and community ties. Ensure that your forms, statements, and documents tell a consistent story. Avoid temporary or speculative plans. Instead, provide concrete steps, dates, and commitments that demonstrate a clear, permanent relocation plan. Quiz time. Question: if someone overstayed years ago but later obtained LPR status, does that old overstay automatically bar a new LPR application today? Option A: yes, the old overstay always bars future LPR. Option B: no, the old overstay was typically forgiven for that prior LPR and usually does not automatically bar a new LPR application. Option C: it only matters for tourist visas, never for LPR. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is no, the old overstay was typically forgiven for that prior LPR and usually does not automatically bar a new LPR application. The prior successful adjudication addressed the overstay-related inadmissibility for that case. However, that same history can still adversely affect non-immigrant applications like B1 or B2 due to concerns about temporary intent. Second quiz. Question: does filing Form I-407 to abandon LPR create a new ground of inadmissibility by itself? Option A: yes, I-407 adds a new inadmissibility ground. Option B: no, I-407 does not create a new inadmissibility ground by itself. Option C: only if filed within 1 year of receiving LPR. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is no. I-407 does not create a new inadmissibility ground by itself. Filing I-407 is a voluntary relinquishment of status that confirms you did not intend to reside permanently at that time. The main challenge later is demonstrating credible current intent to reside permanently, which is subject to officer discretion. In summary, an old overstay is generally treated as forgiven if LPR was subsequently granted for that adjudication. Filing I-407 does not create a new ground of inadmissibility. Non-immigrant visas like B1 or B2 may still be difficult because of intent concerns. The decisive factor in a new LPR application is officer discretion combined with the quality of your current intent evidence. Thorough, organized preparation significantly improves credibility and outcomes. This mind map will center on the concept of permanent intent and branch into the main categories of evidence: housing, employment, family ties, financial footprint, community involvement, personal statement, travel pattern, and document organization. Each branch will include concrete examples such as a signed lease or home purchase, job offer letters, school enrollments, tax returns, bank accounts, community memberships, affidavits, and a relocation itinerary. The goal is to visualize how each piece contributes to a coherent narrative of permanent residence. To wrap up, remember these points. Past overstay issues are generally considered forgiven if LPR was later granted for that case. Filing I-407 does not create a new inadmissibility ground. It reflects that you did not intend to reside permanently at that time. In any new application, officer discretion will focus heavily on your current intent and credibility. Strong, well-organized evidence across housing, employment, family, finances, and community ties is your best ally. Now, let's conclude with a final message. Thank you for watching. If you found this helpful, please like the video, share it with someone who might benefit, and subscribe for more clear explainer content. In the comments, tell us what parts of the process you want us to dive deeper into, share your experiences, or ask follow-up questions so we can help you plan your next steps.